Okay, thanks so much.
Okay, thank you, Lori. Again, Jeff, Durney, and myself are going to be trying to give you some practical information relating to timeshares. Obviously, this is going to enter a lot of different types of practices, so we wanted to try and give you some background information. So I'm going to cover initially just some introductory information, then also some statutory information, and then Jeff's going to take the lead on some of the practical considerations. So we're going to sort of tag team there. And during that point, and really at any point, if you have questions, we can be a little bit informal here. We'll try and answer those as best we can. So getting into the outline, the nature of timeshare ownership, it goes back into the late 70s and maybe even a little slightly earlier than that. It's evolved quite a bit over time, but the two basic types of ownership that you had traditionally seen and still see to some extent are deeded real estate interest versus a right to use interest of some sort. And that's going to get significant a little bit in terms of the practical considerations of how you deal with these things, whether it be in an estate or a divorce or something like that. Those are the two basic types. There is a newer, relatively newer animal, so to speak, that came into effect, which was points memberships, which is really strictly much more like a membership type interest. That kind of makes it a little bit more confusing, but we're talking about timeshare memberships, again, primarily for our purposes here, whether it's deeded or right to use. And in the right to use, you have a perpetual versus term of years. When they started out, very much focused on a term of years. Some of those converted to perpetual, but there are still timed out memberships out there, meaning that they're going to be, from the date of purchase, maybe good for 20 years or 10 or something along those lines, even as short as a year or 3 years. So you have to look at what nature of membership you're talking about. If we talk about the deeded memberships, we're talking about fractional real estate interests. For instance, a 1 week is going to be typically a 1/52nd tenant in common, undivided tenant in common interest in a piece of real estate. It can get a bit more complicated. Some of the resorts have changed around their, how their units are classified and whatnot. But basically, you are talking about an interest in real estate that is deeded. There are also various types of fractional interests, of course, different types of memberships. It could be there are quarter shares out there. You've probably seen some of those locally. 13th shares, 5th shares, all sorts of different interests. If it's an every other year, it could be a 104th interest. It may be classified differently based upon the resort, but the deeded memberships are going to have some classification of what the type of interest is. So you want to know, obviously, whether you're talking about a deeded interest or a right to use interest, because again, as we go a little later on in our program here, it's going to have a difference in probably what you're going to want to do with it and how you can approach it from a client standpoint. Purchase of the timeshare interests, two basic types, not surprisingly. One is an outright purchase, but in my experience, far more common is the finance purchase. It's probably not surprising to some of you that for some companies, their primary business model is not really a timeshare sales company, but a financing company. Your typical purchaser comes in and attends a timeshare marketing weekend and has their presentation and decides to purchase. They're probably going to be financing. So that's a component of what you're going to be seeing as well. In other words, is there still an outstanding purchase loan balance due on this membership? Is it paid in full? And again, that's obviously going to impact how you're going to deal with it as a practitioner in the various components of your practice that you may see this. Financing, again, is not always, but often in-house with the actual timeshare sales company. So you're going to be dealing with an in-house finance company. The other component that goes along with them, of course, are the membership obligations, specifically dues or maintenance fees, sometimes called, that are typically an annual obligation. So that's another financial component of these things that is an ongoing aspect. So even if it's paid in full, most often, I'm not saying there aren't any examples where you won't see this, but most often you will have an outstanding financial obligation for the maintenance fees. So that's something that comes up when you look to deal with these timeshare interests. We can get into this, some of this a little bit more as we talk about the practical considerations. I just kind of wanted to gloss over that. The statutory regulations, this is going to be quick because there really is not a whole lot that's going to, first of all, it's out there, particularly in Pennsylvania, and secondarily, that's really going to impact how you deal with these things. The first thing I have on the outline there is offering plans. When the timeshare declaration of timeshare interest is started, offering plans are filed. They're going to be filed for different states where these timeshare interests are marketed. For instance, Pennsylvania is going to have an offering plan that's filed for the development. New Jersey will, New York, and so on and so forth. It's possible to get waivers of those things, but initially, when the timeshares are put out there are offering plans because it is offering an interest in a real estate development. The most thing that you'll see more often relates to the right of rescission that goes along with these, similar to an in-home consumer contract. There are statutory rights of rescission. Pennsylvania, I believe, is 5 days. New York, I think, is 5 or 7. I know in my practice, we tried to stay with a consistent right of rescission time period from the date of signing the contract, cooling off period, for lack of a better term, where in writing the buyer, after getting home and from the excitement of being either on vacation or their free weekend, their free timeshare marketing weekend, they have an opportunity to cancel these things, which are sometimes exercised. Sometimes you see them, people trying to exercise these years afterward, which of course doesn't work too well. But there is a right of rescission involved. Again, these vary state by state. They will be in, of course, the information that's provided. And going back to the offering plans, and I can't speak to all resorts, but typically similar to what you might see in a resale certificate in a residential property sale in a planned unit development, the buyer is handed all sorts of information. Now it's typically more electronically or on a zip drive or something that includes the offering plan, all the information, the contracts, disclosures, and whatnot. So typically the client will have received that, whether they hang on to it or not is. But the offering plans, first statutory regulation on timeshares, right of rescission. The last is salesperson licensing in Pennsylvania. Timeshare salespersons are required to have real estate salesperson's license, not what we call a full R license, similar to a residential sale, but there is actually a timeshare salesperson license as a specific category. That came into effect, I think, about maybe 10 or 15 years ago. Don't hold me to the date on that, but currently they are a salesperson is required to be licensed. So that's pretty much the level of excitement on the statutory side. I wanted to kind of get through that quickly. I don't know if there are any questions on that boring level of material, but that's what's out there. So again, wanted to go over the types of interests and the very limited statutory regulation that's out there. Most of what you're going to be dealing with, if there's a timeshare dispute, is relative to a contractual obligation. There's either going to be an agreement of sale. If it's a deeded interest, could be an installment sale agreement. Some companies do that. Some do an outright agreement of sale. If it's a right to use, it's going to be a membership contract. But in both instances, it's going to involve a long-term relationship whereby maintenance fees are involved. And if there's financing, obviously there's going to be a long-term relationship with the timeshare company for financing. So with all that out there, if anyone has any questions about that, we can certainly go over that. Otherwise, I think we'd kind of like to jump into the some of the practical side of the timeshare issues that you would typically see when someone picks up the phone and says, "Hey, I have this timeshare. How do I handle it?" And other than telling them to call Jeff or myself, we're going to try and give you some guidance on that. So I'll let Jeff start the lead on that, and we'll both weigh in on those issues.
Thanks, Andy. I do appreciate the opportunity to speak to everyone today. As Andy said, both he and I have had a great deal of experience in timeshare, both in-house and as private attorneys. I wanted to start my comments just with an explanation of what I at least consider to be one of the Achilles heels of the timeshare industry. And that is that there's really no robust resale market. As most of you have seen, the advertisements you've seen, everything about the timeshare industry, there doesn't appear to be a good exit strategy. Once you're in, it's hard to get out. If I buy a house and later want to sell it for whatever reason, there's a well-established marketplace. I know what to do. I list it with the realtor, what have you. I know how to get rid of it. There's no such real good marketplace for a timeshare. Owners will find that they have a difficult time selling their timeshare interval for anything close to what they paid for it. Sometimes you can't even give it away. If I was trying to sell my timeshare that I paid $20,000 for, let's say 10 years ago, I will be lucky in most instances if I can sell it for about $1,500, $2,000. So there's a substantial education that has to go on with a client who is coming in who has paid a lot of money for something, and they believe it's real estate. It's an interest in real estate, and therefore it probably should at least maintain its value, if not increase in value. That is not what happens with timeshares. I've actually even seen, I'm sure Andy has as well, a few transactions where the seller actually has to pay the buyer to take the timeshare from them. And as Andy mentioned earlier, there are two separate obligations with the timeshare. One is the purchase price that you're paying to the developer. The second is the association fee or the maintenance fee that you're paying to a homeowners association typically. That second issue is the one that we confront very often after people have paid off the timeshare and own it outright. They still have that annual maintenance fee. I think around here, at least the resorts that I'm aware of, the annual maintenance fee varies, let's say from $800 to $900 in that range typically. Nationally, I think the average, according to the industry folks, is about $1,000 a year as the annual maintenance fee. So a lot of times the owner is just trying to get rid of that maintenance fee, and they're trying to find a way to get rid of the timeshare that they've owned for a long time. Now, why is it that it is so difficult to sell and to get rid of a timeshare? Part of that is the sales and marketing costs, even for very good developers, usually run anywhere from 50 to 60%. So when you're buying a timeshare, when you're paying the $20,000 in my example, a good percentage of that is tied up in the sales and marketing costs. And of course, you also have the cost of construction and administrative overhead, things like that. You strip away all those things in the resale, and when you're going to resell it, and all of a sudden you have a timeshare interval that on the resale market is worth much less than that. On top of that, the market is saturated with resales. So that's one of the other reasons the prices are down, because there's so many of them available. As Andy mentioned, the industry began in the 70s, and you have a good deal of turnover now, certainly over the years, and it continues. So there are a lot of people, a lot of timeshare intervals out there on the resale market. So when you're dealing with one of the biggest obstacles to resolving issues regarding timeshares is to get your client to understand the harsh financial reality of timeshare values. It's not traditional real estate. It does not appreciate in value, nor does it maintain its value. So that's just sort of an overview of where we go. And what I'd like to do with Andy's help is sort of talk about some of the specifics we have in the outline, the issues that are going to come up probably in all of our practices with regard to timeshares. The first is, how do I get out? How do I terminate my timeshare membership or my ownership? I don't want this anymore. That's a call you will often get. This is probably the most common phone call that we receive, both in our private practice and when we were at the resort. The people just don't want it anymore. They've used it. Timeshare, in my humble opinion, is a very good product as long as you use it. If you stop using it, that $1,000 a year maintenance fee becomes an albatross, and you're looking for ways to get out from under it. One of the selling points with a timeshare was always that this is a deeded interest that lasts forever. You can pass it on to your children and your grandchildren. The reality of it is people vacation differently now than often when they bought their timeshare. Children might not want it. There are new products that are out on the market that you can exit whenever you like. They're contract-based products rather than real estate-based interest. So what do I do? First question, will the developer take it back? That varies by resort. Varies dramatically by resort. It would seem to make sense that a developer would take it back, because why not take the interval back, the timeshare interest back, and sell it again? They don't have to. It's a cheap way to get inventory. They don't have to build another building. They just resell the interval that they took back. While there is not a huge regulatory oversight, at least compared to a lot of industries, there are at least some regulatory concerns with doing that. Number one, the developer is selling the same timeshare interest multiple times. At a minimum, that seems unseemly. And with an industry that has struggled with its reputation over the years, many developers just don't really love the idea of taking intervals back and then reselling them. On top of which, developers can be concerned with having too much inventory. A developer is responsible typically for the maintenance fees on any intervals that it owns. It would prefer not to hold on to the inventory. Most developers, if they take any inventory back, they want to sell it before the next year's fees are due. So developers are in a position where it may be attractive to take back inventory and be able to resell it. They do sometimes have some regulatory concerns, and they certainly have concerns about having too much inventory. So developers, some will take it back, or you can talk to developers, some may not. Andy, I don't know if you want to jump in.
Sure. There is one other component of that. Sometimes inventory does change as a result of upgrades, because you get, mom and pop in to buy a low-level product. Then next year you get them back and you upgrade them, and the following year you get them back and you upgrade them again. That happens. So there is some inventory turnover, but Jeff's correct. Those are basically the concerns. If the developer takes it back, those maintenance fees go toward administrative costs. Very often, actually, real estate taxes on the unit. Some are taxed individually. I can tell you from our experience, the East Stroudsburg, Middle Smithfield Township tax collector had no interest in sending out 52 tax bills per unit. So, our arrangement was that taxes were paid by the developer and were rolled into the maintenance fees. So there's a lot of that concern. When it comes to the developer wanting to take it back, quite frankly, I think sometimes it comes down to practical considerations, whether it's a deeded versus an undeeded unit. A deeded unit, if the developer senses that it's starting to become a default membership, it might make sense for them to take it back, versus a right to use, which is a membership contract, which can simply be canceled. So motivations among developers, will vary as well. It just becomes that practical consideration. We get into that also in estate situations. And Jeff's right there. In our experience, we would see a lot of people calling, when it was an estate or when we realized it was an estate. And there was particularly for New York, probate practice in New York is very different from what I gather. There was a brief window of time where, this could be resolved, or it was just never going to get resolved. And then you're going to be looking at, potential litigation to try and get these units back. But interesting enough, the don't want it anymore comes in a variety of times in estates. Obviously, when the original owners pass, when the original owners, family dynamics change, and also not this may be not surprising to you when the loan is paid off, because whereas the purchase loan is a credit account that is subject to credit reporting, if they're delinquent, just as any mortgage is, maintenance fees are not. So sometimes members owners will pay until they're paid off, and at that point they say, okay, now I'm done. I want to end this relationship. So it occurs there as well. And sometimes you get the financial hardship issue, which again goes to the pending default. So it depends a little bit on the developer's perspective on how to respond to, I don't want this anymore. It depends a little on the circumstances that are being represented to them. Sometimes people just say, I'm done, I don't want this anymore. And very often the response is going to be, too bad, it's yours, you bought it. You can sell it, you have that option. But I have seen, and again, the experience that I have had has been in an estate context. It's more likely that the developer, I think, will be amenable to talking about effectively a surrender. This is not a repurchase. This is a surrender we're talking about. You're not getting any money for it, and that's really the best hope, I think, that you're going to get for your clients, is that the developer will take it back. In other circumstances, bankruptcy is another one. I don't know if we have any bankruptcy practitioners here. I'm quick scanning the group. Local bankruptcy trustees, they don't want these things either. So in a bankruptcy, if it's an impending bankruptcy, it may behoove the developer to be a little more flexible as well, because typically the bankruptcy trustees, I think, just abandon these things, except in Florida. Florida bankruptcy trustees, Florida is like a mecca for timeshare law, so they think timeshares are a valuable asset. But that's another. So estates and bankruptcies are two contexts where I think the developers may be a little more amenable to working something out.
So the next question then becomes, if the developer won't take it back, will the homeowners association take it back? As indicated, there is the annual obligation. That's, at least in my practice, usually where I hit it. As it's not necessarily a default in the purchase. When I worked at Shawnee, they primarily did installment purchase agreements, so we didn't really have a lot of foreclosure work or anything like that we were doing with regard to a purchase. So what I was seeing is when people were paid off, they had paid off their financing, and they were looking to get rid of it. And the question is, will the homeowners association take it back? Now, again, that varies by resort. Understand, just like a homeowners association for your primary residence, a homeowners association goal is to have a dues paying member in every interval here. They base their budgets on that. That's how the economics work. If they have a very high delinquency rate, it throws everything off, as you might imagine. The HOA does not want to own intervals. It really doesn't have, other than maybe for administrative purposes, having a little bit of flexibility if they need to shift some people around to have a couple extra intervals is useful. However, as a general proposition, the HOA wants a dues paying member in the interval and owning the timeshare. If the HOA owns the timeshare, it is not paying any maintenance fees, which means the pot has to be spread among fewer people. Just like the owners, there's no easy marketplace for the HOA to dispose of intervals it takes back. So as a general proposition, the HOA doesn't really want them. There's also a concern if we open the door, if we make a general policy that anybody who wants to dispose of their timeshare and give it back to the HOA, the fear, of course, is there's going to be a rush, and there's going to be way too many people who are interested in turning it back in. And again, all of a sudden, all those economic factors get even more get more dramatic in terms of the economics of doing this. It makes it very challenging to operate the resort. Again, if the owners association owns a great number of the intervals, obviously it's still going to cost the same amount to operate the resort, and now you've got fewer people paying, so the fees go up. There's also some, yeah.
There a second, Jeff. One of the things that I think when someone is looking to get rid of it, it's almost like I'll call it the end of the timeshare relationship. It's like the 7 stages of grief. You know, they start with the belief that it is a valuable asset that they're going to be able to sell, and then they gradually come to the realization that that is not the case. So by the time they're contacting either the developer or the HOA, they're at the point of saying, look, I just don't want this anymore. I just want to give it to you. And that's usually where the conversation is with the with the HOA, because typically not, unless it's an upgrade, there's typically not a buyback. Upgrade's going to give equity, just like when if you're trading in a vehicle, you're going to get equity for your existing membership. But typically when their members are approaching the HOA, it's at the point where they just want to get rid of it. So Jeff's absolutely correct. You have people, the developers or HOA's concern is, I don't want to set a precedent here. We have a policy of taking these back. So they're going to push back on anything that looks a lot like a policy that they have to abide by for everyone.
And so one of the strategies that sometimes is employed is to just simply, I'm going to just stop paying the association fee, and therefore I'm just going to, that's the way I'm going to get rid of it. As many of you will no doubt have had the experience during the foreclosure crisis around Monroe County, you had that very odd situation where your client would be affirmatively look to get ahead of the problem that they saw looming, and would try to talk to the bank about doing some sort of modification to the mortgage so they could afford it. And the banks would say, if you are current, we're not going to talk to you. Once you default, then maybe we'll have a conversation. I always thought it was not really the best way to handle things, but that's what happens. Sometimes you'll see a similar thing happen with the timeshare association. They like people who are current in their dues, and if people are current, they want to at least try to encourage them and try to keep them in as owners at the resort, and therefore you may get at least initial resistance. Just so you know, when you have to foreclose, at least on a deeded interest, if somebody stops paying the association fee, the association, it's a contractual obligation. The association has to go to court and get a judgment against the owner, and then can sell the timeshare at sheriff's sale. The cost to the association to do that is at least $3,000 because of the sheriff's costs. Primarily, the sheriff's costs are going to be at least the $2,000, and then you of course have some additional costs, and of course the attorney fee. So you do the math; it's expensive to go down that road. So if I want to get rid of my timeshare, I think for the best advice, the first call should always be to the resort. Does the resort, either the developer or the homeowners association, have a program whereby they take back timeshare intervals? Some resorts will require, again, remember, as Andy said, these are givebacks. These are not, you're not going to get any money for that. In fact, some resorts may even require, a lot of them require that you be current in your fees at the time, and that you may have to pay for some dock prep fee and some transfer fee. But that, as we'll talk about as we get further dealing with other means to get rid of your timeshare, that may be your cheapest and best alternative if it's available to you. So definitely check out with the resort to see if they have a program whereby they'll take it. We talked about a little bit of financial hardship. Some resorts will require, almost like a short sale, they'll require some sort of letter or affidavit explaining a financial hardship, and that may be a requirement of their program to take it back. But again, my advice is to call the resort first and see if there's a means that they have that they will take back the interval.
One of the things, there's a comment in the chat about, which we're going to get to on the outline. We'll make sure we leave time for it. because it is an important question regarding the third-party resellers. But it kind of brings up a thought in my mind about delinquent memberships, particularly, or even non-delinquent memberships. The member has reached the stage where they realize that their out is not going to involve a check coming to them, but the other way around. Obviously, if it's I can't speak to all resorts. Some resorts, would allow a cancellation by payment, but more likely, it's a situation where the member is perhaps at that point delinquent on maintenance fees or dues. The resort may do one of the two things: try and keep them current by agreeing to to forgive a portion of the arrearage on the dues, so that the member can become current again. Because bear in mind, under these contracts, if you're not current on your dues, you're not even using your membership. The bills keep coming, but you're not actually able to use it. So sometimes they'll want to do that. The other thing that they'll often do is a settlement on dues to cancel it. In other words, you owe X number of dollars in past years maintenance fees or dues. They'll agree to cancel the membership for a settlement of payment of a portion of that. So that's another option that's out there. And in terms of what Jeff said about the members have paid off their loan, so now they're not going to have a delinquent credit account, but they stop paying their dues. A lot of companies do have in-house collection, captive collection firms, which again are not subject to Fair Debt Collection Practices Act, so you can't just send them a nice letter saying knock it off. Some do outsource to third-party collections, or a combination. They start collections in-house and then send it to third party. So that's another thing that's going to happen if the dues aren't paid, is that there's there will typically be some level of collection on it as well. But we do want to get into, because the comment is in there, it's a good one, and it's on the outline for a very good reason. Is the timeshare resellers and cancellation services. What brought that up is the concept of you're going to be paying money to someone. I think the developer would rather that you're paying money to them to resolve it than paying it to a third party, which just kicks the can down the road and doesn't solve anything. But we'll, once at the appropriate time, we'll jump into that.
So and we'll get to that quickly, because I think my comments on the next couple of items are very brief. I just wanted to remind everyone that many timeshares are in fact deeded property. As such, in order to transfer, all owners must sign. Developers, HOAs, in connection with any deed backs, things like that, will not accept a deed that's only signed by one owner. It doesn't do them any good. In estates, divorces, bankruptcies, it's often forgotten to do that last essential step to transfer the interest. For instance, in a divorce, I can't tell you how many times we have seen husband and wife own a timeshare. The divorce decree awards the timeshare to the wife. Nothing ever gets signed. No deed is signed where the husband transfers his interest to the wife. Years go by. Wife has not used it, is now being sued for failure to pay association fees. Wife says, I will gladly deed the timeshare interval back to you. The problem is husband is still on the deed. And now we have to go find husband. And husband has disappeared and has no incentive to cooperate in finalizing the divorce decree. Now, I know there are ways sometimes some people may accept the fact that the divorce decree is there and that has conveyed the interest. I'm telling you, from a real estate perspective, we want to see anybody who's on the deed, we want to see them sign off. So when you're going through the divorce action, just complete that last step. Just make sure that deed gets transferred so that the interest is only in the spouse who is entitled to the timeshare.
There's another aspect of that as well in the estate context. We would often see deeds to married individuals, or not necessarily married individuals, that didn't specify entirety's property or joint tenants of the right of survivorship. So you have one party who's now deceased for 10 years, and no estate was ever raised because they're in New York and they just don't raise estates there. And now you have a title issue, on taking this deed back, where you have a deceased owner and no one to sign on their behalf. So those things do come up as well, some practical issues. But Jeff's absolutely correct. The forgotten aspect of getting rid of the membership, if it's a deeded membership, is the actual deed, transferring it back to either the developer or the HOA, assuming that that's been accepted.
And of course, the same thing happens in bankruptcies. If it's, again, one can argue that you can rely upon the bankruptcy order, the discharge order, but the reality of it is, when you've got deeded interest in real estate, you've got to take care of that. With regard to estates, one thing that we have been able to do when the situation Andy just mentioned comes up is use what we call an heirs at law deed, where you get all the legal heirs to sign off on the interest. Now, obviously, finding legal heirs can be quite a challenge. Sometimes it's easy, sometimes it isn't. But there are ways to do that. But if you try to, while everything is fresh in everyone's mind, everyone is still around, whether it be a divorce, a bankruptcy, an estate, get that thing done as quickly as possible, because it becomes exponentially more difficult as years go by. Now, why don't we next kick into I want to get rid of my timeshare. And the association won't take it back, or the developer won't take it back. What are some other options? As I mentioned, there's not a well-established resale market. So if the HOA and the developer won't take it back, what do I do? So there's a couple of ways, a couple of alternatives. One, of course, is a traditional listing with a realtor. You can list your timeshare with a realtor or a reseller, and there are some legitimate resellers out there. There's an industry-wide one called redweek.com that, to my knowledge, has always been deemed fairly legitimate. There's certainly private companies. You do see these things being listed on Craigslist and eBay, things like that, because they are deeded interest in real estate. Those listings and transfers sometimes are problematic, but you can do it that way. One thing to be careful of: there are companies out there who will require a listing fee. So if I want to list my timeshare with this company, I pay a fee. I've seen them range from $1,500 to $2,500. This company will say, I will gladly list your timeshare for sale. And they will say, what do you want to list it for? And the owner will say, well, I paid $20,000. I'll list it for, I won't be greedy. I'll just list it for $20,000. They'll say, just go ahead and give us our $2,500 listing fee, and we'll go ahead and list it for you for $25,000 or for $20,000. And they will do that. They will put that timeshare on their website, listed for $20,000. And of course, it just sits and it will never sell. So your client, now add insult to injury, can't get rid of it, is not going to get rid of it that way. And it's just paid another $2,500 to somebody. It's a company that's preying on the desperation of people to get rid of things. So if anybody is asking for an upfront listing fee, be very careful.
The next step in that process, and what we saw very often, are the cancel, what I call the cancel companies, and these are very often national companies, attorneys based in places you never heard of, or non-attorneys, offering these services to people all over the place, including Pennsylvania residents. So they're non-licensed attorneys offering to cancel membership contracts. But I'll give you a common example. They're a Wisconsin attorney trying to represent New York residents to cancel a Pennsylvania timeshare agreement and get rid of the timeshare membership. And very often, what is and these are the things that you will see advertised on the television and radio. And I was marveled at some of the bigger ones. I sort of had an internal bet as to how long it was going to be before they were targets of various attorneys general of the states and where they were located. But that occurred very frequently, because basically these companies were offering to perform a service which was a non-service. In other words, they did not have the power to do anything that the member themselves could do, and would often take exorbitant fees. And this still goes on. You've probably had clients tell you this. I paid so-and-so $5,000 or $7,000 because they promised that would be the end of it. Well, certainly the $5,000 or $7,000 exchanges hands, and the cancel company may or may not actually reach out to the HOA or developer to try and cancel this membership. Usually, if they do, they receive a fairly standard form letter back saying, "Thank you for your letter. However, there is no right to cancel under the circumstances." And they're boilerplate letters typically. Sometimes they actually do change the names on the letter. Sometimes they forget. But basically just boilerplate cancel letters, all alleging the typical types of fraud 20 years later, that sort of thing. And
in fact, I'm sure you have too. Some of these companies go so far as to have a pre-printed affidavit that alleges misrepresentations in the sales process. And they just tell people all you have to do is plug in the state and the county and sign it, and then we're good to go. And they basically try to extort the resorts by threatening, well, we're going to call the attorney general and lodge a complaint based on this misrepresentation unless you guys will cancel the agreement or take back the interval.
And I can't, I really can't imagine, what resorts successfully or affirmatively respond to those letters. But typically the where it goes from there. So the resort responds to the cancel company saying, sorry. Then maybe, 6 months, a year later, your internal collection company is contacting the member for unpaid dues, and the member said, no, I don't own this anymore. I've canceled, and the response is, well, you may think you've canceled, but either your company never contacted us, which is very, very common, or your company contacted us, but there's no basis for cancellation. So you still are the owner and still obligated under this membership agreement with respect to ongoing maintenance fees. That was a very, very, very common thing that I encountered. Over the 12 years that I was involved in this as in-house counsel. We'd see that all the time. So there is a very robust industry. It's a secondary industry in the timeshare market for cancels. So Jeff mentioned the resales, but there's the next step is the cancel companies, and the takeaway from that is there's absolutely nothing the cancel companies can do that your client or you can't try and do also. So if you can get, and if is a mighty word, if you can get to your client or the client reaches out to you before they take that precipitous step, you can save them a tremendous amount of wasted money.
Yeah, I'm sorry, go ahead, Andy.
I was just gonna say, if they're willing to spend that kind of money to get rid of it, I think, and I'm not speaking for any particular company, but I think it probably behooves you to try and spend that money to see if you can reach a settlement with the with the HOA to agree to a release and cancellation.
And there's one other iteration of these companies and what they do, and that what I have often referred to as a dump company. This is where the company will approach your client and say, here's what you need to do. All you do is you deed your timeshare to us, to ABC Timeshare, and then you're no longer obligated on your timeshare. You've deeded it. It's no longer yours. Of course, they take a handsome fee to do that. The company, forms an entity that has no assets other than, unwanted timeshares, and they take the timeshare and they let it languish. And then if they are ever sued for non-payment of maintenance fees, of course, they don't care. They're not. It's just a headache for the HOA to ever try to recover that inventory from this dump company. It seemed like a pretty good avenue to dispose of timeshares for a while. A lot of resorts have now undertaken measures to combat this practice. What they have done, whether it's would stand up in court or not, I'm not sure. But for instance, I've seen a resort that says you are forbidden from selling your timeshare to an entity. You cannot sell it to an LLC, to a corporation, anything like that. And while that may not withstand a court challenge, they're betting on the fact that these dump companies are they have to come out from under a rock to challenge that. So I mean, if they're going to be the ones coming to court, they're certainly not coming to court with clean hands. So I've had some companies I understand have done that. Another avenue they've tried is they have required an owner who is selling a timeshare to an entity to obtain what is like a resale certificate at an astronomical cost. They might say, well, if you're going to sell your entity instead of to Andy Wolf, I'm going to sell my, instead of selling my timeshare to Andy Wolf, I'm going to sell my timeshare to ABC LLC. You have to go ahead and give us $900 for a resale certificate, something like that. So the companies, the resorts have tried to combat some of this nonsense, and I think there has been some success and some not. But I think that the cancellation service that Andy just went over is more common now. That seems to be has taken the lead. But that other iteration, I think, is still out there on how people convincing your client, pay us $2,500 and sign this deed, and you're done with it. And as Andy indicated, you get the unhappy surprise 2 years later when you get a bill and you realize that you didn't, or the dump company didn't comply with whatever regulations the timeshare company had set up, and therefore it's still yours and it's still your obligation.
There's another flavor to that a little bit as well, which was the charitable donation. Didn't see that quite as often, but there were situations. Well, I'm going to deed my membership to a charity and get a charitable deduction, which is going to get us into the valuation issues, which is another thing I'm sure you see. I'm going to deed it to this charity, and they're going to take it over. Well, once in a while, you'd actually see a quote unquote charity be amenable to this arrangement. More often than not, I think it never actually came to fruition, but that was another angle that we would sometimes see. Again, I think most often these weren't real charities. They were perhaps names organized in some state. Typically, we would see Florida for getting rid of timeshares. The timeshare company is just not going to recognize that, because it's almost a situation of well, you need to provide me adequate assurances. You're signing this long-term agreement to pay maintenance fees to someone else. What are my assurances that this person or this entity that you're transferring it to is going to accept those obligations and pay it? Otherwise, why should I agree to this transfer? One of the things with transfers, and I can't speak to all resorts, the resort typically also has transfer paperwork. Let's just say it's a good faith. Somebody does buy it. You put it out on eBay, somebody buys it, and you never bothered to contact the resort. So on the resort's records, your client is still the owner. The buyer comes in, wants to make a reservation, and the resort says, "Who are you?" And that happens very, very frequently, believe it or not. It creates problems, and there's accusations of fraud back and forth. So most resorts and HOAs do have some type of transfer paperwork that has to be completed, if for no other reason than just to reflect the new owners on the record. And it was commonly ignored to do that. I can tell you from experience that there were actually individuals who handled those things. They were actually, because of licensing, they were licensed real estate salespersons. They didn't take a commission on it, but they did affect the transfer of the membership. So there's a vehicle out there to do that. It just often was not utilized and creates all sorts of problems. And this is the situation where there has been a bona fide transfer of the membership, whether it be to children or to your best friend or Uncle Bob, whatever. So that is out there as well. So if the resort has acknowledged that a transfer may occur, or if your client has been able to do it, that's a step that has to be taken as well.
Why don't we kick into the last listed subject we have, which was valuation of timeshare memberships. There's a variety of circumstances in which you may need to get a value of the timeshare. There's realty transfer tax, there's an estate, divorce, bankruptcy. My experience, and again, this is my experience here in Monroe County with the timeshares with which we often deal. We typically use the computed value. Computed value, we take the in the where it's a 1/52nd interest, we take the assessed value for the unit itself, and then we just divide it into 1/52nd, and then utilize that as the assessment and compute the value from there. That has been accepted as a matter of course, both by the realty transfer tax folks and in the estates I've done. I don't do divorce or bankruptcy work, but I suspect the same. It would be the same thing there. A points-based product is often done in the same manner, depending upon how it's structured. I know, for instance, at Shawnee Resort, when they have a points-based product, they have combined, I think it's 16 separate buildings. And so you're adding all the assessments for the 16 buildings, and then you have your numerator and your denominator. In any event, you're just doing a simple computed value. Because the values are low, as we've indicated, when you do this math, most are under $2,000. You don't typically get much pushback from anybody because it's just not worth anybody's while. Nobody has pressed me ever to have a formal appraisal done of a timeshare interest because the cost would be prohibitive, given the value. Occasionally, we'll have a situation where we'll have a client in an estate who owns a timeshare outside of Pennsylvania, and there are resale companies, legitimate resale companies, and there's two guys locally that I know who, again, if I have to get a value, I would just reach out to them and see if they can give me a value, put it on letterhead, and that's what I've utilized in connection with establishing values for things. The one thing you don't want to do is you don't want to call Disney and say, tell me what are you selling this for? Because as I said, you're going to get a number that is dramatically higher than the actual fair market value, which is quite low.
Well, you're probably on your following Jeff's point there. You're probably on your own for valuation. I don't know many resorts who are going to give you a value on it, on a membership that was purchased 15, 20 years ago, or even 2 weeks ago. If it's a right to use and it's a term of years, you can take the original contract price and depreciate it and with the remaining years and do things like that. The reality is, you may want to look at the resale market. And Jeff's other point is, I don't think anyone's really going to fight you on valuation of timeshare interests too much. It's not considered truly not really considered an asset of significant value. There's one other question that came through, and I think Jeff did touch on this, is what happens? What's the developer or HOA's perspective when the owner stops paying? Well, a couple things. As I mentioned, a lot of companies have internal collections, employees doing collections. Sometimes they'll send it out to third party. Collections doesn't work. What happens? Well, the developer, if it's a right to use, has typically the right to cancel the membership if they're in default. Now there's some notice provisions, of course, but it can simply be canceled. If it's a deeded membership, it's a little more complicated because that it's going to essentially be just neglected. The developer or HOA is going to continue to pay maintenance, have the obligation to chip in for the maintenance fee income. So the developer has more of an interest in the deeded situation, I think, in not allowing those things to languish, to try and resolve it while it's still, while the iron's still hot, can make something happen. Because if it's an estate, that's several years old, trying to get that deed back is tough. But there is also what Jeff mentioned, the option for the HOA to get a judgment and then, foreclose and, do a sheriff's sale to execute on that judgment.
And as a general proposition, again, most associations don't want to go to that expense. A lot of times when an owner becomes delinquent and does want to get rid of it, that does force a conversation. Again, it's difficult to, advise a client just stop paying for people who are used to paying bills all their lives, to tell them, yeah, just go ahead and default, and then maybe you'll force a conversation and the association will want to move forward and resolve it quickly and less expensively than going ahead and getting a judgment and foreclosing and going through the share sale process, because it's, again, it's going to take some time and it's going to take some money. So again, that's why I still think that an early and frank conversation with the association often will yield the best results.
So there's a question here. Any comments on what happens when a timeshare company, seller, homeowner association goes under? I think, as Jeff mentioned earlier, typically there is a homeowners association, not always, particularly if the developer is still, is still actively selling. But an association is created, I think, with that in mind, just as with a planned unit development. Once the original declarant sells a percentage and transfer declarant rights, and once they retire to Florida, there is an entity in place to make sure that the common areas are maintained, common areas and amenities and whatnot are maintained. So I'm not sure if I've seen one go under. Perhaps that does happen, but again, you do. The concept is you have an owners association in place to avoid that potential. We're getting close to our end here. I know we started a couple minutes late, so we don't want to shut anybody down if you have other questions. I guess we're trying to gear this to the typical types of things that come up. I guess my takeaway from this is, understand what the original developer's primary business is. If you have a loan, an outstanding loan on it, you got to deal with that. If you have an estate, use that angle to approach them. Similarly with the bankruptcy, divorces are a little different. We often did see divorce decrees where specifically, you get. I'm not sure what the negotiation was, whether it was considered an asset or a liability that had to be allocated, but we'd get divorce decrees saying it goes to goes to my husband or goes to my wife. So that's somewhat of a neutral situation where it's just simply affecting a membership transfer by divorce decree. But particularly in the estates and the bankruptcy situations, I think the developer has an incentive to work with you to avoid just a lingering problem. And similarly in the I don't want it anymore. If your client has been a long-standing member in good standing with the company, that may carry some weight as well. So use all those angles, but for God's sake, just stay away from the timeshare resellers. I don't mean to paint everyone with a broad brush, but I'm using a pretty wide brush there. I think as a general matter of advice, the dump companies or the cancel companies, your client is just going to spend a lot of money unnecessarily that might otherwise be used to pay you and to also to assist as having something potentially to offer as a settlement to cancel the membership directly with the HOA or the developer. I said I want to leave a couple minutes for any other lingering questions here. They've been popping up on the chat box. They haven't all popped up, so let me just see if I can see what. I don't know, Jeff, if you want to look through those as well. There was one question about Unfair Trade Practices Act. Sure, you can allege that. Typically, we would see that after they've 15 years later, after they've paid off their loan, and suddenly there's an unfair trade practices claim. That's typically where those where we would see those, and we say, well, geez, if it was unfair trade practice 15 years ago, what were you waiting for? That's alleged. I would say that if the company has done its homework and has all of its disclosures and paperwork in order, there is a right of rescission. It's there for consumer-based, complaints. I don't think that's going to go very far. Certainly, you can allege it. as a further basis to try and do this. But again, typically, in my experience, we wouldn't see that early on when it should have come in. If it were, an actual bona fide claim, we'd see it after the member decided they didn't want the membership anymore. All right, I'm not sure how to get out of the chat bar here on the side, but I didn't see anything else. I think we covered all those. If anyone didn't get their question covered, we can try and do that real quick. But otherwise, I would say thank you all. Appreciate the audience and the response. We weren't sure what we would see in the way of an audience on this, but I'm very happy to see so many having signed up, and hopefully this gives you some guidance. I think Jeff and I will probably still take a few calls, but perhaps this gives you some background information to be able to to advise clients on how these things work, and the other side of the other side of the conversation from the timeshare company or HOA's perspective.
Okay, great. Thank you so much. I appreciate your time. I'm sure everyone is just trying to soak it all in, right? So be sure to send your forms over to me as soon as you can so we can get them recorded. And if you do have any other questions, feel free to email them to me, and I will definitely forward them on to the attorneys that presented today, okay? Thank you so much, everyone. Have a great day.
Thank you.
Good program.